Senate Bill 11 is titled the Utah State-Made Firearms Protection Act, but it is often referred to as Utah's Firearm Freedom Act. This bill states, in essence, that guns made in Utah, sold in Utah, as well as ammunition made in Utah, sold in Utah, are not subject to federal regulation. As you will note, the first page of the bill addresses constitutional rights enumerated to the states in the 2nd, 9th, and 10th Amendments, acknowledging that these are contractual agreements with the citizens of Utah from the United States. As in previous legislative sessions, there are a few gun bills that are being run this session. I want to clarify early on that this bill doesn't really fit into the gun bill category. Although this bill does address guns, this bill is about our state's immutable right to establish control of our own rules and laws in our state. This is not rogue action. Utah is not alone. The bill you have before you contains language very similar to a bill recently passed in Montana and in Tennessee, and a version of the same bill, excuse me, with very similar language, is being proposed in 20 other states right now. 8 other states are preparing to do it in their 2010 sessions. So that's 29 states. 58% of the states so far who are so exasperated with the federal judiciary granting Congress permission to disregard and discount the 10th Amendment that we are taking definitive action. I want to tell you a story about a man named Roscoe Filburn. You have a little picture of him on your desk. Roscoe Filburn was a farmer in Montgomery County, Ohio. He had a small herd of dairy cows, and he raised chickens and sold milk and poultry and eggs. And he also planted a bit of winter wheat to help with the feeding of his animals and to help with his family's food. He ground it for flour. But he did not sell any of his wheat on the market. This was in the fall of 1940. He planted 23 acres of wheat, and he harvested 462 bushels. By doing so, Roscoe Filburn broke the law because under the Agricultural Adjustment Act of 1938, a federally mandated quota and price support system that the federal government had put in place, Roscoe was only allowed to plant 11 bushels on his available acres and harvest 223 bushels of wheat. As a result of this crime of planting in a time of need and having a bounteous harvest, Roscoe was fined 49 cents a bushel. Now remember, this is in 1940, and in 1940 a loaf of bread cost 8 cents, and gas was 10 cents a gallon. And Roscoe's fine equaled $120, which could have paid about 4 months' rent. For his unauthorized planting and yield, again in time of want, Roscoe was sent a bill from the federal government. Roscoe fought his way through the court, and finally in 1942, the Supreme Court ruled that by growing too much wheat, Roscoe had indeed broken the law under the Interstate Commerce Clause. Let me remind you again, this is Roscoe planting wheat on his own land, for his own use, for his own family. The federal government ruled he had broken the law under the Interstate Commerce Clause because now he would not be buying wheat on the open market. Congress had decided that they had not only the power to regulate the supply side of the supply and demand, but also they could regulate the demand. The court ruled that by producing his own wheat, he had effectually affected the open market. I guess they needed to read Adam Smith's Wealth of Nations. I think they skipped that part in their schooling. Just as our issue is not about guns, Roscoe's issue was really not about wheat. It was about who could control Roscoe and what he grew. What Roscoe really did was frustrate Congress's plan to control the citizens within the state. So SB 11 is not so much about guns, but it's about who can control what we can make and produce in our own state. And some of you have expressed concern about the constitutional note. So let me tell you, there are 4 cases cited in the constitutional note, and one of them is Roscoe Filburn that we just talked about. 2 others address, let's see, one is United States versus Lebanon and United States versus Petrucci. They also discuss intrastate firearm sales and regulations. And to this issue, I would submit that the aim of this bill is not to eliminate federal controls. It's just to make them irrelevant. Background checks could still be done in the state. We can decide if we want them done. We don't need to have the federal government tell us to do it. So the constitutional responsibility of the legislatures, especially at a state level, is to test the constitutional limit. It's the duty of our state to challenge the courts. This is not about accepting status quo. It's about questioning status quo. The one other case in the constitutional note that I have yet to address was the one Gonzalez versus Wright, which is about marijuana being granted to grow in California for medicinal purposes. And I don't want to be misunderstood to be getting involved in the marijuana debate, but the federal government came in and said that California did not have a right to make that decision on what could be grown in their state because of the possibility that it might go somewhere else. I think what's really important in this constitutional discussion is Justice Sandra O'Connor's comments and her dissent on this. Now, let me quote this sentence. It's very important. She says, quote, "If the majority is to be taken seriously, the federal government may now regulate quilting bees, clothing drives, and potluck suppers throughout the 50 states. This makes a mockery of Madison's assurances to the people of New York that the powers delegated to the federal government are few and defined, while those granted to the states are numerous and indefinite," unquote. And Justice Clarence Thomas wrote, "If Congress can regulate under the Commerce Clause, then it can regulate anything, and the federal government is no longer one of limited powers." Well, a lot of you know that I enjoy making bread, and I enjoy sharing bread. And I realize that if I grind wheat and make bread and share it with all of you, that I have thus violated the Interstate Commerce Clause according to the court's decision in these cases quoted in the constitutional note. So in a mood of civil disobedience and defiance, I decided to give you all a loaf of bread this morning. Although I do have to say, this little loaf of bread is not of my making because I was here too late last night, so maybe I didn't interfere with the market too much, but I did avoid challenging FDA rules by choosing to give you a loaf of bread that I did not make. The Constitution of the United States provides for us more freedom than any people have ever known. These are blood-bought freedoms. The federal government has occasionally been an irritant, then it has been infringing on our powers, until now it is just actively intruding. There are a number of bills that are in the legislature this year, 13 bills that I know of in our legislature that address our state's sovereign right to make decisions in our own state, to have control over our own laws and regulations, and to say to the federal government, what part of shall not infringe do they not understand? I'm open for questions on this bill, Mr. President.